Hello, David Martin here, and I want to talk a little bit with you about what is the model long-term disability case. Okay, we've talked about the model attorney, the model client, and now we're going to talk about the model case, but one particular type of case, the long-term disability case. We'll talk first of all about the initial phase of a long-term disability case, and that starts with your policy. If you suffer an accident or an illness, then one of the first things you need to do after you get medical care and treatment, of course, is to look at your policy and make sure that you follow the rules in your policy. The policy is going to have a notice of claim provision many times, and that's where you have to give notice that you have a claim. You have to give that notice to the insurance company. If you don't give them notice and too much time passes, that can be harmful or fatal to your claim. So the model long-term disability case, or LTD case as I will refer to it later, requires you to look at that policy and make sure you give proper notice to the claim at the address that's listed in the policy. And then next, you also will have to give proof of loss within a certain amount of time to the insurance company or the plan administrator at the address that's given in the policy. Okay? Now, if you hire an attorney to help you with that initial claim process, that attorney, of course, can assist you with those details as long as you furnish the policy to the attorney. Now, once you have given that proof of loss and the notice of claim has been furnished, then basically there is about 45 days that is supposed to transpire before you have a decision. So if you filed a claim on June 1st, then by July 15th, there should be a claim decision. The insurance company has 45 days to make that decision. Now, there can be circumstances beyond the control of the insurance company where they need more time. For example, they ask for medical records from your doctor's office and the doctor is on vacation and is not available to approve sending the records, and so maybe the records are delayed. Well, if the insurance company has such special circumstances beyond their control, they can take another 30 days as long as they give notice of that within the time period required. All right, and usually that's got to be within that 45-day time period. They're supposed to give notice, hey, we can't make a decision yet, and so we have to take another 30 days. Well, now you're waiting 75 days for your long-term disability benefit, but that's legal. That is within the ERISA claim procedure regulation. Sometimes additional special circumstances can arise. Now again, these special circumstances are matters beyond the control of the insurance company. It can't be, half of our staff here at the insurance company was on vacation, or we had a lot of people out sick, or, anything that's within their control. They can get other people on the claim, so that wouldn't be an excuse. It has to be something beyond their control that constitutes a special circumstance. If it's within their control, that doesn't count. No extensions for such matters. But if that happens again, they can take another 30 days. And so again, before that lapse of that 30-day extension occurs, sometime before day 75, they're supposed to say, we have another special circumstance where we need another 30 days. So then they can add another 30 days up to a total now of 105 days. That means that from the time that you gave them proof that you were disabled, 105 days passed until they finally are supposed to make a decision. There can be some other wrinkles in there, and that is if the insurance company sends you a letter or calls you and says, we need this information from you. We need your W-2, for example, from the prior year. You better get it to them right away, because they are not going to count those days where they're waiting on information from you as against their 105-day total. Okay? So if on June 5th they ask you for your W-2 and you don't send it to them until July 5th, that 30-day time frame is not going to count against them. The clock was stopped while they were waiting on you to give them information. Okay? So it's in your best interest with a disability claim to furnish the information required to the insurance company right away. All of that is part of the claim process, and hopefully within that time, with the model long-term disability case, a claim decision is made. If it's not, then the claim can be considered deemed exhausted. That means you can now take your case to court and you don't have to go through the claim procedures anymore because the insurance company isn't following it. All right, that concludes that portion. Thanks.